we wrestle with the challenge in this country, as in other places, relating in particular to the Basara, or the sand. We have had challenges around these issues. The Constitution of this Republic way back provided some special protections under Section 14 then, that secured for them special rights in relation to the Central Calgary Game Reserve in particular. And they were singled out for special and heightened recognition in terms of their movement within the reserves and an appreciation of the special nature of the Basara as a people. You are aware that there was that infamous case, Khoisan and others, which was the longest lasting civil case in the history of this country, but also interesting from a number of perspectives. One of the things that happened during the case was an amendment of Section 14, in terms whereof the special protections that were available to Basara were removed during the case. The outcome of the case is now a matter of record. And it, in critical respects, established the pre-existing rights of the Basara in relation to particularly the Central Calgary Game Reserve. But no sooner had that case been resolved than there arose two critical difficulties from a legal point of view. The first was that they are a hunter-gatherer community, mobile in small bands, but also in a way somewhat sedentary. Their mobility arises in part from their conservatory approach to the wilderness, the environment. They will not hunt in an area for too long. They hunt and move so that the area recovers, both in terms of the vegetation and the wildlife. They, for instance, will not kill an animal that is with calf, heavy with calf. They understand, they know these things. So there's a lot of indigenous learning from them in the space of conservation, which we could learn a great deal from, and maybe we haven't. So there were problems in relation to their hunting, and now licenses were required, which licenses were withheld. Their right of moving freely, and also the right of access to water. I raised these issues because they ended up before the courts. And I raised them because I was personally involved in them as the attorney in the Khoisan case. I was also involved in the case of Matsipani Mosakanya, a case in which they asserted, the people of the Central Calgary Game Reserve asserted their right to have access to underground water in the reserve. and there were some prospecting boreholes that had been sunk, which were claimed by the Kalahari District Council, and which, when probed, it was established that they in fact were not owned by. These were prospecting boreholes and therefore could not be claimed by any of those people that were laying claim to them. And that is a case in which the Court of Appeal came out scathingly against the government of this republic. These are things we must be very upfront about, very honest in acknowledging the faults and follies of approaches that were taken by us in relation to indigenous people. And the court described the conduct of the government as callous and an abuse, a denial of the rights of access to water. And so it established a fundamental and very interesting principle that any occupier, lawful occupier of land, is entitled to sink a borehole on that land and abstract water for personal use, which is exactly what the communities of the Central Kalahari Game Reserve in Mutumelo and Metsiamanong and Gugama were claiming. And so the court affirmed their right to do this and settled this dispute. We appreciate, we acknowledge, we embrace the pronouncement. And then there was another difficulty. I said there were two. The second is there's a dispute as to how many claimants there were in the Roy Sesana case. It's a strange dispute, strange conflict, arising critically from the part of the government. The government asserted that the claimants were the 162 who were able to sign powers of attorney. We were talking about a community that is in the middle of nowhere with limited access to the outside world. A case is going on at the High Court. You require powers of attorney, imposing immense logistical challenges and financial burdens on them. And on the basis of that slight technicality, it was claimed that some of them should be excluded from having been claimants, who were in fact claimants. So the courts adopted a very narrow approach, famished jurisprudentially. And I'm being very honest, very candid about these things. As a lawyer and as a jurisprudent, as a human rights practitioner myself, I must be very candid about these things, so that you don't leave this country with an impression that there's some cover-up. We're very honest about the faults and follies that we've encountered. And so another case arose that implicated exactly who was or was not a claimant in the original Roy Sesana case. And now it involved the burial of one of the members of that community who had lived in the reserve, had gone out of the reserve to go and seek medical attention, had unfortunately died. And a position was taken that he could not be buried on his ancestral land. And this matter went all the way to the Court of Appeal, which came out with this pronouncement that he could not be buried there. I'm sure a lot will be written about this. I'll probably at some point in my life write something about this myself, reflecting on the jurisprudential implications of this approach for the human rights disposition and standing of the country. But the end was that he could not be buried. Now this was a pronouncement of the court. And again, I raise this because I was personally involved with my instructing attorney here, who is now the Minister for Justice and Correctional Services. I'm sure he will correct some of these. So we faced these. And as fate would have it, I now happen to occupy the highest office in the land. And the first order of business was to confront this very same issue and find a way of righting the wrong that had been done and laying down some bright lines for the future. And this is exactly what happened. Within the strictures of the law, the party that had a judgment in its favor, being the government of the Republic, entitled by law to abandon this judgment, operated within the same law to file at the court a notice of abandonment of the judgment, so that we vacated it in order for us to then proceed and bury this individual in the CKGR. And on Human Rights Day, we did. We buried him. And again, as fate would have it, I was there, personally. Made some scathing remarks of and concerning the decision, by which I stand firmly and unapologetically. It was not a disparagement of the judiciary. It was a statement of very serious jurisprudential principles to which I'm faithful unto death. And so we are here now. You come at a time when we have taken a clear stance in favor of human rights. We uphold, we recognize, we promote the fundamental rights of everybody, but more particularly the indigenous people. Because we appreciate that even as we attempt to equalize, there's a disproportionality of impact on those who are at the margins, in the underbelly of the same society. And I wrote about this in part in the Australian Journal of Human Rights way back, when I was dealing with a policy of the government called the Remote Area Development Program. And I posited in that article that one of the fundamental mistakes made in relation to indigenous peoples is to view them through the lens of the dominant communities. Even their organization must mimic the tribal organization of the communities that surround them. I called this insistment. And I inveighed against it. So my views on indigenous peoples, and in particular the Basara, are well known. I'm sure they've traveled quite extensively in the manner in which I've articulated them in that journal article. And I raise these issues so that I foreground whatever discourse we will have, so that you appreciate where this government stands in relation to indigenous people. In particular, and I refer here pointedly to the Basara. And this is a position that we are on. And on the 7th of February this year, I appointed an interministerial committee to travel around to examine these issues and come up with a report. And so your visit is timely. Your experience, deep domain understanding of these issues, your background as a human rights lawyer, advocate, and thinker will enrich the reflections and the policy recommendations that will come from this exercise. That was by way of a welcome to you. Welcome from a kindred spirit.
Thank you.
A fellow sojourner in the arena of human rights. One who has fought, one who bears the scars of battle in relation to the rights of the indigenous people, among others. So thank you very much. We welcome you. Thank you.
I traveled Africa, I've met leaders, I've met presidents. I never had somebody talking like you. This is really a head of states. I've met many of them. And that's why you were elected in November. I think that's when you took office. At that time, I had applied to be a special rapporteur because the position was vacated in October. And I listened to your inaugural speech. I wasn't appointed yet. It's on that day, hearing you, that I decided that if I were appointed, I'll really do the best possible to visit first, and before everything, Botswana. I would just want to thank you, Mr. President, on behalf of I think I can speak for indigenous peoples in Africa and globally, for your leadership. Because in my view, the greatness of a human being or a nation is assessed on how that person of that nation deals with the weakest section of its population.